Well, in the uncleared swap world, the world that has predominated for many years to date, people have traditionally used a bilateral agreement, an ISDA master agreement between the two counterparties to a particular swap. And because there was no clearing involved, there was no need to involve a third-party clearing member. It was just a principal-to-principal bilateral contract between two parties. Now that we're moving into the cleared swap world, there's a need to bring in that clearing member, and therefore we're seeing a shift in the documentation, the approach to documenting swaps. So although the instruments themselves are economically very similar, the documentation is completely different. And what we're seeing in particular is due to the fact that the Dodd-Frank Act imposed an FCM agency model for the clearing world. And what that means is that FCM, so your futures commission merchants or clearers, are clearing through a bilateral agreement with their customer, but then there's another piece of the equation, which is that the customer is executing with another party pursuant to a separate agreement. There are three major constituencies that are impacted. The swap dealers, because they're going to be the ones executing trades in this new market. They're no longer going to be relying on ISDA master agreements to govern those transactions and those executions. Also the FCMs themselves, so the clearing members are going to need to amend their documentation with their customers to take into account cleared swaps because they didn't contemplate those before under their existing clearing agreements. In addition, the customers themselves, of course, they're going to be facing both their clearing members and their executing counterparties and having to amend their documentation accordingly. The first thing that FIA produced is actually a standardized execution agreement, and that is an agreement that can be entered into between a swap dealer and its customer to address the execution of cleared swaps and the parties' responsibilities to submit them to clearing. The agreement also covers what happens if a swap fails to clear. What are the consequences of that? How are the parties going to deal with that potential eventuality? That agreement is not a required document. It's completely voluntary. I should point out that there are certain cleared swap markets where executing counterparties actually don't rely on such an agreement on the assumption that the trade will clear. You know, they don't worry about what's going to happen if something fails to clear, and so they don't necessarily use that document. In addition, FIA is working on a standardized addendum which FCMs and customers can use to amend their clearing agreements to take into account cleared swaps. Now that document, I do expect that most FCMs are going to require. Their cleared swaps are, although sometimes economically similar to futures, they do have certain distinguishing characteristics that really do need to be captured in this addendum. You know, for example, swaps don't often, at least at the moment, trade on organized exchanges, and so therefore the way they are closed out in the event of a default, for example, is slightly different. They also present certain tax issues potentially that differ from futures. And there are, other sort of rights and remedies around swaps that necessitate a slightly different approach than from futures. The Dodd-Frank Act provided in Section 731 that the CFTC is to promulgate standards, documentation standards for swaps, both uncleared swaps as well as cleared swaps. The CFTC first issued its cleared swap rules in July, so they're really relatively recent, and the comment period on those rules closed on September 30th, so just not long ago. The proposed rules as they came out actually do have implications for the FIA ISDA execution agreement in particular, not so much the addendum. And the reason they have implications for the FIA ISDA execution agreement is that the rules provide that FCMs should not be permitted to impose limits on a customer's execution, or actually an FCM can't require that its customer reveal who its executing counterparties are. And I think the CFTC is concerned about possible conflicts of interest that might be produced if that were to happen. And so therefore they have proposed various restrictions on cleared swap documentation. Well, what we're already seeing is that even though some of these documents aren't final and the rules aren't final, Parties are moving forward with getting documents in place so that they're ready to clear, particularly once mandatory clearing, becomes effective. So we see some people working off, for example, the latest draft of the FIA addendum, recognizing that those documents do take some time to negotiate. They are new. People are sort of considering what approach they want to take to this documentation for the first time, how they might want to amend it or tweak it depending on who their clearing member is and so forth. But people are starting to review the documents and starting to negotiate with their FCMs to get those documents in place. The execution agreement is also starting to be used a little bit, where appropriate or where parties think it's necessary. That document was published, as I mentioned, in June as version 1.0. I should note that it was published alongside an explanatory memo that sort of goes through the agreement and explains, what each provision, is intended to accomplish. And the memo does point out that this agreement is being published in its version 1.0 version, and it may be superseded by, market developments, by, the new regulations that are coming out and are not yet final. Well, I will say these documents are refreshingly short. They are somewhat complex, but only to the extent that they need to be. I think the fact that they're standardized and hopefully everyone is going to be starting from the same, negotiation point, in terms of first draft is extremely helpful and should allow market participants to get the documents in place in a timely manner. I think parties should be able to put them in place much more quickly than an ISDA master agreement, for example, for uncleared swaps. And it'll be particularly beneficial for parties who already have a clearing agreement in place with their FCM, so they don't have to negotiate that from scratch, but all they need to do is add this addendum, which is 7 or 8 pages long. I think the only thing they're expecting to do here, and this is consistent with Dodd-Frank, is to set forth general standards that the documentation has to meet, and then it's sort of up to the industry to comply with those standards and develop forms that work within those standards. And I should again reemphasize that these documents are not mandatory. If parties chose to come up with their own form of document to address matters related to cleared swaps, nothing prevents them from doing that. But I think it's much easier to start from a common starting place and across your market participants and FCMs, and so I expect to see a broad take-up of the use of these documents where people think they're appropriate.